Tēnā koutou katoa. Nau mai, haere mai. Welcome to the LDAC webinar series. Today we're going to talk about ways to achieve compliance and enforce legislation. We're going to take a deep dive into Chapter 22 of the legislation guidelines. Our focus will be on how we can design legislation that encourages compliance, while also implementing enforcement mechanisms that are both effective and proportionate. My name's Guy Beats and I'm the Deputy Chair of the Legislation Design and Advisory Committee, and I'm also a non-public service member of the Legislation Design and Advisory Committee, and I work at the Institute of Directors. There's going to be three parts to our webinar today. I'm going to start with a short presentation about what LDAC is and what it does. Then we'll talk to the panel and we'll get them to introduce themselves shortly. And then we'll take your questions, and you can use the Q&A button at the top of your screen. That's the top right-hand side. So let's talk just a little bit about what LDAC is and what it does. The Legislation Design and Advisory Committee is made up of members appointed by the Attorney General to support good legislative design. It's a mixture of public service and non-public service members. And all our members are voluntary or unpaid for their LDAC work. In the case of the public sector employees, their time is loaned by their employer. PCO helpfully provides secretariat support, including advisors to support the committee, which we are very grateful for. Members have a broad range of backgrounds. We draw members from legal and policy teams within departments, Crown entities, as well as academics, lawyers, barristers, and consultants. In my case, I'm an economist. A broad range of skills and experience is important because good legislative design is multidisciplinary. It's not just about the law. We have three functions. We publish and maintain the legislation guidelines and supplementary material. That's the government's handbook for good legislative design. The most recent edition was updated in 2021, but the guidelines have a decades-long history and are direct successors of the Legislation Advisory Committee guidelines. We carry out education and engagement activities, like this session today, but also with departments and on a range of issues. Both these activities extend our reach beyond our advice functions. It's common to see submissions to select committees refer to the guidelines, and ministers are required to address consistency with the guidelines and cabinet papers for bills. Our advice function applies at two different stages. The bulk of our advice is prior to introduction of a bill, when we advise departments that come to us and have a conversation about proposed legislation. We also make submissions to select committees. So how can LDAC help you? We aim to support good lawmaking. We are guided by the guidelines and supplementary material that I spoke about earlier. The guidelines aren't just about policy, though. They're about the expression of policy in law. This means you'll not find us giving an opinion on policy, and that's really important in the context of what we do. It's important to remember that guidelines are just that. They're guidelines, and they're not rules that must be followed. And our goal is to help ensure that conscious design choices are being made in terms of that legislation design. And finally, let's talk briefly about today's webinar. Today, the focus is on Chapter 22 of the guidelines. And when it comes to enforcement and compliance, we're going to talk about three things: designing legislation with compliance and enforcement in mind, ensuring that enforcement and compliance tools do what they're intended to do in the most effective and efficient way possible. And we're going to spend most of the time talking about those two. And to round out the discussion, I'll talk briefly about regulators and monitoring. Now, if I can turn to Matthew Smith and Dagny to introduce themselves. Let's talk to Matthew first.
Kia Koto. I'm Matthew Smith and one of the external members of LDAC, and in my day job I'm a barrister at Thornton Chambers in Wellington. I'm looking forward to contributing to the conversation that we're going to have today on Chapter 22 of the guidelines.
And Dagny.
Kia ora tātou, I'm Dagny Baltic-Mins. I'm also a Deputy Chair of LDAC, and in my day job I am in the legal team at the Ministry of Justice, and I'm happy to be here this morning talking to Guy and Matthew about compliance and enforcement.
So really important topic. I mean, so often we focus on the design of the legislation itself and what it's trying to do and how that turns policy into legislation. Today, we're going to focus on what do you do about it? How do you deal with those compliance and enforcement things? So let's talk first about how do you design legislation for compliance and those enforcement considerations? So let me turn first to Dagny. What are the key factors that should be considered during the policy design stage to promote compliance and provide for enforcement?
Well, thanks, Guy. It's really tempting to want to jump straight into a discussion of individual compliance and enforcement tools and mechanisms. But before we do that, I just want to take a step back and look at some of the basic design issues that apply to all legislation, but will ultimately foster and encourage compliance. So ensuring compliance with the law begins with good design. And at the most basic level, laws that are well structured and intuitive increase the likelihood that people will comply without the need for complex enforcement processes. So as you'll all know, there are many elements that contribute to good legislative design. And one key aspect that I'm going to emphasise at the outset, and this really applies to all aspects of legislation, is that good legislative design requires a thorough policy process, which in turn requires time. Rushing legislative design is likely to lead to unintended consequences, and the effects of that can be amplified where those unintended consequences are in your compliance and enforcement provisions. On the more specific side, before we get into talking about individual tools, I'll just take a few minutes to go through some of the fundamental design and process starting points that you should consider when you're thinking about how to achieve compliance and enforce legislation. The first one, and perhaps most importantly, is that you should always keep in mind the importance of the law being clear and accessible. If a law is too complex and too difficult to understand, people can fail to comply simply because they don't understand what their obligations are and they don't know why they're important. On the flip side, the simpler the legislation is, not only will it be easier for people to understand, but also it makes enforcement more straightforward. Ambiguities in the law can lead to loopholes which people can seek to exploit. So the fewer legal technicalities a person has to interpret, the better their understanding of the law and their adherence to it should be. So secondly, I think it's important to plan and allow sufficient time for effective consultation with relevant stakeholders. The people who will be subject to the law, as well as the people who are going to have to enforce it, ought to have a say in how the law will be structured. Early engagement can reveal potential challenges and resistance points. Stakeholder engagement is particularly important in identifying practical concerns that might really have an effect on compliance. For example, if laws impose high costs on businesses or some other sector, they're going to look for ways around it if they think it's unreasonable that they should bear those costs. By incorporating stakeholder feedback into your design process, you can improve compliance and also increase trust in the system as a whole. And thirdly, I think you'll need to understand the regulatory tools that are available to you. Many people's minds will automatically think of compliance and enforcement being achieved through including criminal offences and accompanying sanctions and penalties. While this is one option, and it's an important one, there are a range of other regulatory tools that are available to help promote compliance with and/or enforce legislation. And knowing what those tools are and the circumstances in which you might want to use them is one of the crucial parts of the design process. To give you a few ideas, some compliance and enforcement options that don't involve creating criminal offences can include education initiatives and public engagement, self-regulation of the people or entities that are subject to the regime, relying perhaps on existing civil remedies, perhaps providing for detailed complaints and investigation powers sitting with your regulator, providing for pecuniary penalties or having an infringement offence regime are all some of the other options that you can use other than just criminal offences. The last key point that I'm going to touch on here is the importance of ensuring that the law can be enforced in practice. And I'm just going to give the example here of the leaky building crisis, which was a really good illustration of how difficulties in enforcing the legislation in practice led to really bad outcomes. So while there are 1,001 issues with the leaky building disaster, one of the key things was that local authorities and certifiers didn't have the resources and capacity to monitor and ensure compliance with the building standards. So because of the practical difficulties they had in actually doing that, it just led to an escalation of bad effects.
Yeah, it's interesting, isn't it? I mean, one of the things I take out of what you've talked about is actually just almost a feedback loop, where you kind of think about your legislation design, what you're trying to do, and then the enforcement piece, and then looping that back to see whether or not it actually is having the effects that are intended. So thanks for that, Doug. We're going to turn to Matthew now. Can you expand a bit on terms of the regulatory tools that Dagny's talked about, and touch on what government's role might be in enforcing that legislation? You're muted.
Sorry, second time lucky. Sure thing, Guy. Dagny mentioned 9 regulatory tools that can be used for enforcement purposes and ultimately achieving compliance with a set of regulatory requirements set out in statute. And I'll just go through them briefly and highlight what they are before we move on to consider some of the issues associated with choice of fit for purpose tools. The first of them is education initiatives and engagement, and these are tools that are often used in contexts where information is required to achieve compliance and to change thinking. Education initiatives and engagement, they can also be used in complex situations or contexts where a wider range of compliance mechanisms, so a wider range of tools in the toolbox for seeking to ensure compliance with regulatory requirements as required, or a more proactive approach might be needed. The second of those 9 tools is warnings, and warnings can often be used in response to a first-time infringement or a minor misconduct in terms of regulatory obligations, or unintentional or inadvertent breach of obligations that have been set out in the statute. Third, you have self-regulation as a tool, and it's usually seen in highly specialized or technical industries, and the experience of LDAC and kind of use of self-regulation is that it tends to work best in environments where stakeholders have a strong incentive to maintain high standards, public trust, and industry integrity. And Dagny's example of the building industry and some of the changes relaxing the building code requirements in the 1990s that triggered the leaky building crisis, that was an example of an area where more thought, and certainly with hindsight, should have been given to the extent to which self-regulation fitted based on the industry and the industry participants and the incentives that existed. The third of the 9 tools is relying on or modifying existing civil remedies. So taking as the starting point that there are a range of civil remedies that exist either in other statutes or that have been recognised by the courts as part of the common law, and then modifying them by statute. And that's usually appropriate in scenarios concerning private disputes between individuals, either actual people or legal persons like corporates or trusts or the like. And in some cases, the government overcontracts debts or wrongs such as negligence. The fourth tool is pecuniary penalties, which are non-criminal monetary penalties that statute will set out as to be imposed by a court in civil proceedings, applying the civil standard of proof, so the balanced probability standard, rather than the criminal standard of beyond reasonable doubt. Now, while these aren't criminal sanctions, an important thing to always bear in mind there is that pecuniary penalties, in addition to having a financial sting, being an obvious intention of them, can have serious reputational and financial effects on the person or entity that's the subject of a pecuniary penalty order. The other tools, and I'll just go through them a bit more briefly in the interests of having a seminar that is more informative in terms of the wider sweep of compliance and enforcement issues, are infringement offences which are of a criminal nature but don't result in criminal conviction, so a lower order criminal tool for compliance. Management bans, enforceable undertakings, and other civil orders are the other 3 tools that we commonly will consider and recommend for consideration of as part of designing a compliance and enforcement regime. And just focusing on one of those three, which is the management bans, they tend to be particularly effective in protecting markets, industries, and the public from individuals whose behaviour has demonstrated a clear risk to lawful business practices. And you see it really commonly in licensing situations where you'll often have a licensing regime established on the basis that licensed individuals need to satisfy a fit and proper person or some other equivalent test. And if the initial satisfaction of that test falls away, you in effect have the banning of that person from remaining in the industry because they no longer meet the fit and proper person standard. Now, I should emphasise that these are by no means an exhaustive list of the tools. The 9 that I've just highlighted and spoken to a little bit, or a complete description of the circumstances in which they are used. And the reality in terms of ensuring that you've got a fit for purpose compliance and enforcement regime is that you'll often require a combination of more than one of those regulatory tools to ultimately achieve an efficient and effective compliance model. And some tools, of course, may be included to be used only for a breach of a regulatory requirement that's set out in legislation, and others might have thresholds that apply to using them. So an exceptional circumstances threshold, for example. And that really, and it's the last point that I'll make before handing back to Guy, is that the consideration of whether or not there should be thresholds or limitations to accessing and utilising particular compliance and enforcement tools really underscores the fundamental need when designing for compliance and enforcement to step back and ensure that you've ultimately what you're proposing fits with the statute book and the experience and wisdom reflected across the statute book as a whole as to the kind of compliance and enforcement tools that exist when they are suitable for use and when they're not, and how to structure the inclusion and the exercise of them in a way that is not only fit for purpose within the environment in which you're looking to regulate, but will ensure that there are proportionate outcomes and a proportionate suite of responses to the problem that the compliance and enforcement tool is provided to be able to assist a regulator to address.
Yeah, that's great, Matthew. And thanks, Dagny, too. I mean, I think one of the things that if our audience hasn't got a message already about this, that is we talk about compliance and enforcement very quickly, but actually there's much, much more to it in terms of making the regulatory system work and legislation work than perhaps first meets the eye. To pull the threads together in terms of what Dagny and Matthew have talked about, let me make a few points. Compliance starts with thoughtful design. You need clear and accessible laws to get the level of adherence to that you're seeking to achieve and the community is seeking to achieve. If you rush into that, if you rush the design process in terms of the things that Matthew and Dagny have talked about, there will be unintended consequences, and we're trying to avoid those in public policy as much as possible. If you have early consultation with stakeholders, you're going to avoid some of that, and that means that people have a view about how that law will work, but also how it's going to be enforced, and that's absolutely critical in this regard. If you ensure laws are designed with clear enforcement mechanisms, that avoids crises like the leaky buildings issue that both Dagny and Matthew have talked about, and where that enforcement capability or capacity was actually lacking. And the government should only intervene where private enforcement is insufficient. Matthew's touched on self-regulation as one example of that and the circumstances around that's useful. Tailoring enforcement tools to the specific context is also crucial. Some industries may benefit from education and warnings as one example, while others might require stronger penalties. And you've got to have some level of thinking about how that enforcement regime is going to work. So now we've done that, let's now turn our mind to the process for ensuring that the compliance enforcement tools chosen are effective, efficient, workable, and appropriate, i.e. they do what they say on the tin. So I'm going to turn first to Dagny on this one. What are some examples of effective mechanisms to promote compliance and support enforcement?
Oh, thanks, Guy. Well, the first point that I'm going to note here is that whatever a combination of compliance and enforcement tools you're looking to use, they should together form an effective system. So it's really important that you design the system as a whole, thinking about how the parts are going to work together. So it's generally not a great idea to just copy elements from other systems and plonk them into your regime. You really need to think about how it's going to work in the context of your system as a whole and make sure that all of the parts work together. The next point is that effective enforcement mechanisms will vary significantly depending on the context, and each mechanism that you use should be proportionate to the issue that you're trying to address. So this links back to what both you and Matthew were saying before about the needing to tailor tools to specific contexts. For example, if you've got industries with very high public safety risks, like aviation, for example, you're often going to need something that imposes strict liability on participants, so strict liability offences and significant penalties. Other contexts where the stakes are not so high may benefit from more graduated enforcement regimes, or they might rely primarily on education and self-regulation. An example that I like to look at is the Privacy Act, where you'll see that in that context there are actually very few offences in that Act, and none of them are in relation to direct breaches of the information privacy principles. Instead, the enforcement of the principles is achieved through the establishment of the Privacy Commission as a regulator who has these important education functions and a really detailed complaints and investigative system. And the offences that are in that legislation are more in relation to not complying with the regulator's requests than they are in respect of the privacy principles themselves. Another key point to emphasise here is that to be successful, an enforcement system should align with societal values. Otherwise, there's a risk that the law will be flouted and it will be very difficult to enforce. So a nice example of this is an act from the 1920s in the US, the Volstead Act, which was also known as the National Prohibition Act. And I think most people can probably guess what that was about. It prohibited the sale and transportation of alcoholic beverages, and it included fines and jail sentences for the manufacture, sale and movement of alcohol, and it provided the government with really strong powers of search and seizure and enforcement. And it was intended to reduce crime and corruption and improve the nation's health. However, it was really out of tune with national feeling, and it lacked public support. And despite the government's attempts to enforce it, it actually led to widespread illegal activity and a black market in alcohol. And it was ultimately repealed in 1933, not having been a success. So this is a good example of how sort of overly strong or strict enforcement provisions was not the best approach to take because it lacked buy-in from the public, and a more graduated response would probably have been more successful. The other thing that I just want to touch on briefly before handing back to you, Guy, is to just talk about the importance of providing for monitoring within your compliance system. So monitoring is essential for identifying non-compliance early and for being able to address it without having to move to your sort of more severe enforcement mechanisms. Effective monitoring can take many forms. For example, it could involve regular audits by a regulator, or it might involve self-reporting, or it might make use of a complaints system. So you've got lots of choices to make about how you might want to do monitoring. A really clear example about how the lack of effective monitoring led to serious compliance and enforcement issues is in relation to the global financial crisis in 2008. There was a lack of oversight and monitoring in relation to financial regulations, and that was a major factor in the collapse of those institutions, which ultimately led to a global recession. So that failure prompted widespread regulatory reforms in the US and in other places, and perhaps benefit of hindsight, if the monitoring had been better initially, we might not have seen such a disastrous collapse in 2008.
Yeah, and feedback into the legislative design too,
Yeah,
eh?
exactly.
And all of that, and Enron looms large in the story you've just told, I think, which had some other effects as well. So that's really helpful in terms of how do you make this effective. But there's also another thing in here. I think the tendency, and sometimes this can come about with community pressure, is to throw the book at things. And I think you've highlighted nicely, Dagny, if that doesn't fit with the wider community, then that may not work. But turning to Matthew, how do we ensure that the enforcement measures that we're putting forward are proportionate and tailored to the risks involved?
Thanks, Guy. That choice between the various enforcement options it really does need to be based on a robust and transparent policy analysis of how appropriate the option or options that are up for consideration are in relation to the purpose or purposes that you're trying to seek to address the mischiefs that you're seeking to address through the legislation and the particular circumstances and regulatory system in which the compliance and enforcement tools will operate. And that is in an environment where, in terms of proportionality, it's often said, and the metaphor I think is always a helpful one, that you should never use a sledgehammer to crush a nut. And that applies particularly aptly here, as in many contexts, for identifying relevant and choosing ultimately fit for purpose compliance and enforcement tools for the harms or the mischiefs that you're trying to address through the legislation that you're looking to design and ultimately implement. And LDAC commonly will identify a four-step process that you can use that can be helpful for conducting that analysis to ensure that sledgehammers aren't cracking nuts. And of those four steps, so step one is to consider the harm that's caused by the breach and the nature of the conduct involved. And that is important because it helps you align yourself with the statute book, getting consistency and conformity across the statute book as a whole, recognising that the statute book tends to reflect accumulated knowledge, experience and wisdom. And by considering the harm caused and the nature of the conduct involved, you'll also more likely to understand the types of options, the different tools that are expected generally, as reflected in the statute book, to be used for particular types or kinds of conduct and harm that Parliament in other contexts identified as mischiefs and has sought to address through regulation. Step 2 of 4 is to consider what your objective for enforcement is and whether the enforcement options you're considering using will actually achieve that objective. So, for example, if deterrence is to be the primary objective, using a $1,000 or $500 infringement notice as a penalty may work to deter very small businesses or individuals, but it may have little deterring effect on a large corporation that may simply decide that the breach is worth paying a $1,000 fine for. And it's an example of just tailoring your compliance and enforcement mechanisms to really the nature of the stakeholders that will be regulated, and amongst other things, the incentives that they have to comply with regulatory requirements based on what the enforcement tools are when they don't comply. The economic theory of the efficient breach theory. Can I breach in an efficient way by absorbing by gaining more money from the wrong and absorbing any penalty that might be ultimately associated with being caught for doing the wrong? The third of the fourth step is to consider the practical implications of the various options, and this is really important and requires asking yourself whether the options you're looking at pursuing are actually going to be workable in a practical sense in the circumstances in which they're intended to operate. And it loops back to, I think, a common thread running through a number of the points that we've made, that there is a real need to ensure that you understand the area, the market, the industry that's the subject of proposed regulation, based on that, what is likely to work and what is not likely to work for marketplace participants, the public interfacing within that area or industry, and you're choosing tools, regulatory and compliance and enforcement tools that will be fit for purpose in the knowledge of that. And going back to a point that Dagny made earlier, stakeholder engagement is going to be really important for that, because stakeholders that are operating in that area or industry are likely to be best placed to give you advice as to the practical environment and, by necessary implication, what will or may work or not as a compliance and enforcement tool there. So that's step 3. Step 4 is kind of the standing back step, which is standing back and considering what is fair and equitable. So, for example, consider what regulated groups' ability to challenge decisions, compliance and enforcement decisions will be to help you to really carefully work through and determine the nature of procedures, protections, checks and balances that might be required to ensure ultimately that you're striking the right balance between having tools that enable compliance with and ensure compliance with the requirements that are being set through legislation, but appropriately at the same time recognising and protecting and safeguarding the rights and interests of regulated parties. And that really, in a nutshell, is what proportionality is addressed to, ensuring that your outcome is proportionate to the rights and interests and responsibilities that are affected by a regime that's addressing mischief that has been identified as necessarily requiring to be addressed through legislation. And in that sense, proportionality is crucial to maintaining public trust and compliance. So if enforcement, for instance, is perceived as overly harsh or arbitrary, you might have people resisting the regime entirely, and in that sense, the whole purpose and the benefits that are sought to be achieved won't be realised because the regime won't be respected. And that the final point to make is, and it flows out of that last point, is that discretion will often be required for enforcement, and the very practical importance of discretion is to help to ensure that there's trust and confidence in the integrity and working of the system through giving the enforcers of the system the ability to choose a range of enforcement responses, which might actually be none or a written warning, educational responses, to ensure ultimately you've got the most fit for purpose response appropriate to the particular facts and context of any breach of regulatory requirement.
Yeah, it's interesting, isn't it? Because but also doing that in a way that doesn't subvert the overall intention of the regime. So there's a kind of bit of a balance to be struck. So to pull all those threads together, there are many examples of the various tools available to achieve compliance and enforcement. There's too many of them for us to cover comprehensively today. The guidelines certainly help that. I think the key is to understand there are that many options and work through a policy process to determine the most appropriate tools. Real-world examples of compliance and enforcement mechanisms that have either been successful or unsuccessful can help us to make those choices and provide that advice. But when looking at those examples, it's also important to understand the differences in what's being designed and more particularly the context. I want to say a few brief words about regulators monitoring and measuring compliance. Dagny and Matthew have already covered off, what sort of tools you've got available and how to make sure that that's proportionate to the nature of the enforcement and the regulation. But there's also a question of who does that regulation and the monitoring and measuring. So regulators monitoring compliance are also a part of that puzzle. We're not going to cover that in detail today, but I wanted to make a few key points. Effectiveness of a regulator depends on aligning its powers and responsibilities with the goals of the legislation. So that's the same as the tool question, of course. It also seems key to define the regulator's functions clearly, considering tools like monitoring, compliance and enforcement options, licensing and transparency. Building in an appropriate method of monitoring for compliance is also important. The benefits of regular and systematic monitoring are huge, as Dagny's outlined. Not only can you detect non-compliance and address it earlier, but it also provides insights for future regulatory adjustments and therefore contributes to the overall success of the regime and possibly other regimes as well. And finally on this topic, even successful regimes require review and monitoring as time passes, and the factors contributing to its success change. That's one of the reasons why in regulatory impact statements there's actually a piece for evaluation. And just to finish off, I'd like to give our panel the final word before taking your questions using the Q&A button at the top of your screen. So if you haven't seen that, it's that little Q&A thing with a question mark in it. We'd be really grateful if you could ask a few questions, things that we've talked about today that are worrying you or things that were unclear. So let's go to Dagny. What are the final key messages you want to leave with our audience today?
I've got two things, Guy. One of them is that you've got to design your regime from the ground up for your context. So be wary of lifting and shifting from other regimes. You're going to make sure that the tools you are using are appropriate to you and proportionate to your context. So pick and mix is not such a good option when it comes to designing regulatory regimes and compliance. The other one is that good overall design, including clarity and certainty of purpose, will flow through to compliance and enforcement aspects. So the better your design is overall, the better your compliance and enforcement should be.
That's great. And now it's Matthew's turn. What are the couple of key messages you want to leave our audience with today?
Thanks, Guy. Just three that are really all related. The first is that consistency really is key. So consistency in enforcement action ensures fairness and helps to establish clear expectations for regulated parties. And it's kind of partly a winning hearts and minds thing in a way, that if justice is both seen to be done and done, people are more likely to understand and respect the integrity across time of the regulatory environment that's set through legislation. So consistency is key. There are strategies such as clear enforcement guidelines that can be developed to ultimately explain and ensure through explaining that there is a consistent approach to enforcing compliance obligations, and training for enforcement officers or regulators can be used to also help to ensure that decisions across time are made consistently across varying cases. Consistency, and this my final point, consistency doesn't, and I stress this, doesn't mean inflexibility. There is room for discretion, but that discretion should be applied uniformly. So, and by that I mean that if there's a default rule or a default position for exercising a particular enforcement tool, that default position should be applied unless there is a justification for flexibly departing from it. But if, and it's not uncommon for there to be such justification, if that justification exists, then every similarly situated party should have the benefit of the exception or the discretion on a consistent basis, and that will just ensure that you have, in terms of the benefits of consistency, the justice being done and seen to be done in the way in which the regulatory obligations are enforced. You have that across time, with the benefits of that for those that see the regime in existence and in operation, and their compliance with it as a regime of integrity.
Yeah, it's interesting. Hey, thanks both of you for your contribution today, and those passing or final thoughts. I encourage people to use the Q&A button at the top of the screen if you've got questions for our panel or for me. Happy to take those. I wanted to go back, Dagny, though, to the point you made earlier in our discussion, and that is this question of context. The notion that says, one size doesn't fit all, but also that context can change. Can you talk a bit more about that from your own experience and the things you've seen where that, in some senses, where that's been done well and where it's been done not so well?
Sure. Well, one thing that we do see regularly in LDAC, and I've seen it also in another capacity when I've been working on BORA vetting of new legislation, is a real temptation to look to other regulatory or other types of regimes and say, "Oh, I like the look of that offence provision. We'll have one like that." And so you just kind of move it across, and when you do that, you both risk kind of creating some incoherence because it hasn't come from your system, and then you also kind of end up not necessarily, because you haven't built it from the ground up, you haven't necessarily identified specifically for your context what is the exact, say if you're talking about an offence, what is the exact conduct that we are looking to form the basis of this offence. why is it that this particular thing in our context is bad, and how do we need to design this offence provision so that it specifically targets the things that we don't want people to do. The risk when you borrow an offence provision and the wording and the structure of it from somewhere else is that it won't fit into your context very well. And you can then end up with difficulties of interpretation. What exactly are the elements of this offence? And then obviously difficulties in compliance and enforcement.
Do you think some of that's more difficult with amending legislation than it is if you're starting from scratch? And are there examples of that?
Yeah, I think that amending legislation has its own challenges, and it can be more difficult than starting from scratch because you're trying to work around what's already there. And then you're sort of, you get some really difficult issues trying to figure out you've already got a pre-existing legislative environment that you're trying to understand how your new amendments are going to fit into, and that can in itself be quite a difficult sort of analytical problem. It's just understanding what the environment that you're already working in is, and therefore what effect any small changes or amendments are going to have. It can be easier to just start from scratch with a new piece of legislation that will establish its own boundaries and, bring its own context up with it. Slight fly in that ointment is that any piece of legislation is, of course, in context with other legislation, so you still do need to know what your legislative environment as a whole is.
Yeah, it's really, really important, eh? I want to just turn to Matthew briefly too, because I want to go back to this proportionality question, and more particularly that kind of graduation of things like infringement notices all the way through to kind of essentially throwing the book at people. I think what that means is underlying that is some way of thinking about it, and obviously Braithwaite's triangle and that set of thinking is part of that. What's your view of how to kind of think about that, have a kind of almost a theory of enforcement?
At a conceptual level, I think it's helpful to, and building on what Dagny was saying when you start there first, if you're kind of looking at a lift and shift exercise in terms of, well, what do some other statutes provide as enforcement tools? It can often be important not only to look at what those tools are in the statute as it sits on the statute books, but to have an appreciation of what sits behind them, because there'll, for some of them, be years of experience on the part of the administering department, regulatory agency, administering those enforcement tools, and a whole lot of lessons that might be reflected in guidance documents and policy documents that sit behind otherwise broadly and sensibly and deliberately broadly conferred discretions to reach to different enforcement tools on the pyramid of more to less proportionate response. And those can be as helpful and critical sometimes to understanding where those tools actually fit into the regulatory environment as it's administered in practice, and to understanding the lessons, the wisdom that experience with those tools in a particular environment have given. And I think that's an important line of inquiry for the lift and shift approach that Dagny's referred to, but it also ties into your question, Gaia, for what should you be thinking about when designing or choosing a proportionate suite of tools that will give you the opportunity for instance, a graduated response to regulatory harms or regulatory violations of requirements that ensure that you can do lower level, and particularly when new legislation is introduced that fundamentally changes the operational requirements in an industry, it can often be really helpful to have warnings and the education and information related tools to help to lift up understanding of the regime and how it operates in practice, and secure through that, particularly in the early weeks and months in particular, help to ensure through that an understanding and a respect for the regime that will mean across time that it has fit for purpose. But you don't want to be going back to Parliament on a regular basis kind of building the plane while it's flying, so to speak, and looking to add in greater sanctions and regulatory response tools that you didn't have from the outset. So you want, and I think what flows from that is it's important to think about, well, I need to stand up a new regime, and what are the enforcement and compliance tools that will help to stand it up and to give the tools and the flexibility, where flexibility is appropriate, to lift up understanding and compliance. But then once you've got to the point that you can and should expect those that are regulated, the industry, to have that baseline knowledge, you want those tools to ensure that the economic efficient breach arguments have appropriate sanctions, and also to ensure that if there is very harmful conduct that emerges, you have the tools to ultimately respond to that in a way which recognises the nature and extent of the harm. So having the full suite of options and the flexibility to choose the enforcement tool that's tailored to, proportionate and fit for purpose to the harm, and the expectation as to understanding and compliance with the regime across time is really important to ensure that you've got there, but is also a point that Guy made earlier, something that it's a constant work in progress. While legislation as it's drafted will remain static, the world which the legislation regulates, the social and economic and cultural environment, expectations, mores, they will change. They will inevitably change because the world keeps moving, even though the legislation remains static. And for designing legislation, including for compliance and enforcement, you want to do that as well, to ensure, the courts talk about it in terms of the ambulatory approach to interpreting and applying legislation, to ensure that there is enough flexibility built into the airplane that has to keep flying, to ensure that it can keep flying and it will get to the destinations that it needs to fly to.
Yeah, it's interesting, right? As we've been talking, I'm thinking, so often, and certainly in my previous work too, you kind of get to the enforcement bit and you think, oh, that'll be straightforward. And it clearly is not. And the other point about it is it's almost, I guess, the other temptation with this is to think it's set and forget, where in fact some of the stuff you just talked about, Matthew, is an ongoing work in progress. But I think we've also touched on consultation, and I briefly touched on regulators as well. I wanted to turn to Dagny though, because there's a thing that occurs to me, and I'd just like your view on it. So often policy gets developed, and with the following, when we do a whole range of consultation externally, what's your view about the involvement of people who are actually involved in the enforcement, so the regulators, and the sort of role that they can play in informing some of these choices around enforcement?
Well, I think it's really useful to talk to the people who are the regulators and have to, administer the system, because though you've got to make a number of kind of design choices about what you're going to do, and the ease with which you can actually do something is always going to help you understand whether or not that's a sensible provision to make. There are a lot of, I do think that's a really valuable resource, is to talk to regulators about how has this worked in practice. Can you in fact be across this many, monitoring this many points of data or whatever across this amount of time? Is that feasible? You've got all sorts of considerations. Do you have enough staff to do that? Do you actually get meaningful data out of doing this? Once you've collected it, is it the sort of information that you can then take action on? This feeds back into your points earlier, Guy, about the information has to come back from the system and feed into it to know whether in fact it is working. So you can design a beautiful theoretical model that you think ought to work on paper, but it doesn't work in practice for some reason that you as the policy advisor can't see, and only the regulator who's had lots of experience of trying to administer this sort of system in practice will be able to spot and say, aha, but that won't work because. So
Yeah,
yeah, so my advice is talk to regulators, ask them what works and what doesn't.
and it reinforces quite a lot of the stuff that the policy project has on its website about exactly that. Hey, the other thought that occurs to me, and I'll turn to Matthew for this. When you're often working with people who are being regulated, essentially, and in some cases, you and your colleagues in the barrister community are also supporting those people where there's enforcement action being taken. What's your view about the extent to which those people being regulated, one, know they're being regulated, but secondly, that they understand the nature of the enforcement and actually are, that changes their incentives. What's your perspective on that, Matthew?
So really good question, Guy. The answer is that it will vary from regulated industry to regulated industry and can often and often does vary amongst regulated parties. And you might have, depending on the nature of the regulation, the regulated individual or legal entity, there might be a very sophisticated understanding of what the rules are and very clear and consistent and considered engagement across time with not only understanding what the statute sets out, but understanding the way in which it's administered in practice, including the enforcement and compliance policies and guidelines that inform discretion. And I have in mind there that some industry, and it will partly depend on the nature of the industry players and the incentives that they've got to, for instance, for reputational reasons, avoid the Dominion Post front page factor of facing a public allegation that they have not complied with regulatory obligation, particularly if there's a public health or safety or welfare dimension to it. No, or even with financial institutions, they would want to avoid stories that have reputational risk associated with being seen to be ultimately taking approaches on things that are unfairly taking advantage of borrowers in any way. So you can have that extreme, highly sophisticated and motivated regulated entities that have the disciplines not only of the formal enforcement tools, but the reputational and market perceptions based incentives that can very strongly ensure that they keep to the letter of the law, but also work really closely with regulators to understand any areas of discretion and uncertainty and resolve it before there is an intentional or not action that gets close to a line that may trigger reputation or other risks. The other end of the spectrum, you can have some industries where there isn't some regulated parties where there's not a really strong and clear incentive to understand legislation, which might, in terms of the subject matter of it, be extraordinarily complicated to understand. So there will be, and it's kind of a very human response, there will be, and human action, there will be a good faith attempt to understand at a high level what the bright lines are of what can and can't be done, and to ensure that there are compliance with those bright line understandings. But it's only in response to an enforcement step or an escalation being taken that there is a true understanding of some of the nuances, details, risks, problems associated with the regime for the party, and it's only then that they might come to lawyers for legal advice and assistance. And sometimes it's too late because the damage has been done then, and it's working to mitigate the harm and, for instance, keep someone within an industry if there's a fit and proper or other licensing regime that's at risk of them falling on the wrong side of, or working with a regulator to try and work out what an appropriate and proportionate response is in the circumstances, and work in a collaborative way, but recognising and respecting the important independent role and functions a regulator has to choose and to implement a proportionate fit for purpose response, but balancing that against the rights and interests and responsibilities and the very practical, real world human or financial consequences of a regular taking enforcement action. So
yeah, absolutely. When, as you've said that, Matthew, I'm thinking about this happening in real time with the climate-related disclosures, where directors got legal advice, and the legal advice was because of the nature of the liability they faced, was to, and the instinct of the directors in exactly the circumstances you're talking about, was to scale back the level of disclosure, which was never intended. And we've outlined that actually in a piece of work we've done with KPMG called Lessons from the Frontline, which basically outlines exactly what you've described. I've just got one final question for Dagny, and that is, in the work you've done, and you've seen others do in terms of this enforcement space, how do you think the people in our audience today and others should think about this kind of capacity of the regulator? Because you've touched on it a little bit in terms of how do you do the monitoring stuff, but can you just tell us just a little bit more about how you think about that kind of regulator capacity, which we haven't really touched on?
Well, I think number of ways that you could think about it, and you from a very sort of from one angle is to think about like how many things can a regulator focus on and hope to try and enforce or deal with in any sort of given period of time. So you don't want to set up a regime where there's kind of too many focuses for a regulator to try and deal with. You've got to think about which of the things are the most important, and so either have a sort of limited set of objectives or tasks or roles, or you have to have some kind of prioritization system that, even if it's not, baked into your legislation, that that your regulator will be able to apply, so that they know that where they've got too many participants, too many things to try and watch over, too many bits of behavior they're trying to monitor, that they know which ones are the ones that they need to target. That's as kind of in a very sort of regulatory sense that applies, but it kind of also applies more or equally as in a kind of very, criminal offending space, where you're thinking about, say, who are your prosecutors in the system? Is it police prosecution, or are you perhaps relying on agency prosecutors, say, in fisheries space or something like that? And again, you've got to think about what are the resources that you have. Is it practical for to expect that every instance of this particular piece of bad behaviour will actually be prosecuted? Because there are resources involved in bringing a prosecution. You need prosecutors, you need court time, you need paperwork, you need discovery, and all that sort of stuff. So again, this kind of comes back to the proportionality question again, is that you think about the size of the thing that you're creating, and have you got enough resources to do that thing, and is it important enough that you do it on that scale?
Absolutely, and think about the nature of the organisations, and just not think because you've got a regulator or an enforcer of one kind or another, where that's the police or some other specialist regulator, that's going to be fit for purpose in terms of the new thing you're designing. And I guess I should just briefly tip my hat to the other part of the legislation guidelines, which deal with creating a new regulator, a new public body, because that's a consideration with this as well. Well, we could talk about this all day, but I just want to focus as we finish off on the main takeaways from our webinar today, and also to thank Dagny and to thank Matthew for their contribution today. That's been fabulous. So let's just pick up a few key points we'd like to emphasise out of the end of this. Designing an effective compliance and enforcement regime requires a careful balance between clarity and practicality. If you've learnt nothing today, it is a large task designing these compliance and enforcement regimes with many contributing factors, and requires a thorough policy process. This will take time, and as Dagny has pointed out, and I think Matthew's reinforced, rushing into this, you will do so at your peril with a whole bunch of unintended consequences without some care. Good legislative design practices can prevent a lot of headaches down the road. And finally, enforcement needs to be proportionate and acceptable. There's a lot of reading on this as well. Use helpful resources in the legislation guidelines in Chapter 22 in particular. If you read Chapter 22, then you can probably read Chapters 23 to 27 as well, because that provides guidance on creating new or relying on existing civil remedies, creating criminal offences, creating infringement offences, pecuniary penalties, and imposing time limits for enforcement. We are going to have another webinar in a month or so, and we're going to be focusing on how you work with LDAC and how you do that in a way that actually helps frame departmental policy, helps frame the legislation, and gets the best possible legislative design. We'll let you know when that is very soon through the Secretariat, and we look forward to seeing you then. Ka kite anō.